Hello everyone, I am Takshama Maheshwari and today we have with us Advocate Shashaank Sharma. He is a practicing lawyer at Madhya Pradesh High Court and he has completed his LLB from Faculty of Law, Delhi University. He has been practicing before the Supreme Court of India and he is currently working at Additional Advocate MP's office. Thank you, sir, for accepting our invitation for this session.
Thank you.
Okay, so sir, let us start by you telling us that how did you got your interest in pursuing the commercial law and how did this subject interests you?
Actually, it all has happened out of the blue. Well, I was just a student in my faculty, in my college, I mean to say, in the Faculty of Law. So since that point of time only, when I got some students who want me to teach them contract. So I started teaching them and all of a sudden I get into it. See, when you have to teach someone, you have to go और ज़्यादा आपको काफी डिटेल में जाकर पढ़ना पड़ता है. So at that point of time, I actually realized this is something very great subject. Why it is great subject? Why I specifically use this term great subject? Because for a student, if a student has gone through this subject, so one thing I can assure you that you can have a tunnel, you can build a tunnel to enter into other subjects as well, like Sale of Goods Act, like partnership, like SRA, TPA, NIA, in a contrasting character wise as well. You can have a command just by going through contract in IPC dots as well. This is the substantive portion, and once you've been through the substantive portion, you can very easily go through the commercial portion as well. So this is what my journey is. So until and unless I got that opportunity of teaching some students, I couldn't be able to enter into it. This was a very beginning story.
Yeah.
Ignition point.
Okay. So basically, according to you, contract is one subject that we law students should focus on more.
Exactly. One should always focus. Realize, as per my experience is, actually, universities taught the students number of subjects. As of if you're talking about a 3 years course, then you must be having 30 subjects. But as far as if you ask me that how many subjects and or how many concepts should we deal with, then I would suggest you that not more than 15 or 16 or max to max 20 concepts. Once you've been through those 20 concepts, or rather 20 words, if you get the clarity of only 20 words, you can have a command over the law, because law is nothing but it's a common sense. It's something which has been happened with you commonly in your family, in your out of the family. This is something law is, because law ka origin kahin bahar se nahi hua hai, that has been originated from a society as well. So this is what the beauty of the law is. So this is one thing.
Yeah, definitely. It is such a nice thing that you said that the origin is only between us and nothing and nowhere else. Yeah. So what exactly is the work of a commercial lawyer? So what does he actually do?
See, as a work of a commercial lawyer, see, there are a lot of works. The very first thing first, you have the understanding of drafting. What do you mean by drafting? Means, in a very simple language, you have to understand that what is the need and requirement of your client is. What your client actually wants. So you have to draft it in a very formally manner. So first of all, you have to know the documents. For example, rent agreement, partnership deed, okay, and the sale deed, sale and purchase deeds. Okay, so these are the things you must know. Second thing, or at advanced stage, if you've been a commercial lawyer in some of the companies, good companies, and you might have got the work of vetting the contract. That means you have to correct the contracts.
Okay.
I can give you my example. When I was in one of the firm, namely AKJ. So I've been a part of AKJ Association. So I've been worked with them, and majority of the work which we used to perform over there is the vetting of contract. So what is this vetting of contract? That means alterations, corrections, as per the need and demand of the clients. What they want, what are the changes they wanted to make in the contracts, So only a legal person, by applying a legal brain, he can understand that this clause might lead to some put some negative impact on the over the client, or this might put him in certain losses. So, and vetting means you have to correct those clauses and let them make them negotiable with each other. So this is what your work is as a commercial lawyer as well.
Okay, okay. So that's a great amount of work that a commercial lawyer has to do. So, what are the three main attributes or skills, according to you, that a commercial lawyer must acquire before, moving into this direction of being a commercial lawyer?
So the very first thing is the understanding. Understanding that what is his basic requirement. Once you see why I am saying so, that there is an understanding, there is also a reason that why there is an understanding. The first and the foremost question is that who is a lawyer?
Yeah.
Lawyer, according to me, if you ask me who's a lawyer, then out of the several and the various definitions, I have one important definition, that he is nothing but he is an extension board. He's an extension board. Now why? Because if you wanted to plug in the charger of the laptop and you don't have the switchboard, then you have to put it into extension. A client actually wants to represent himself before the court of law, and client can do so as well. But in certain cases, it's not been feasible for a client to appear himself before a court. So therefore, he hires a lawyer. Now, why? Because he expects out of a lawyer that what are the feelings and emotions and relief which a client want, that can only be filtered by a legal filter called so-called legal brain of a lawyer, and then that can be manifested before a court of law. Definitely. So therefore, the first thing requirement is the understanding. A lawyer can understand what he wants. So the very first thing is that you should have an understanding that what he wants. Secondly, the second most important requirement is that one should have a command over the subject. Yeah. See, it might be happen, or it might be visible, or you might have understand in this way ki it may be a theoretical approach, but it's not like that. When you are a student, majority of get into a practice, this theory and practice has a two different aspects. No, it's not like that. Theory and practice, although they have a two different ways and paths, but actually they are absolutely interconnected with each other. Yeah, I can say like that practice are the pipelines, or practice are the arteries, and theory is the blood. Yeah. So until unless you have the blood, your heart won't be able to pump. So second most important point is that you should have a command over a subject. So until unless you command, you couldn't be able to draft properly. You couldn't be able to present the things properly. You couldn't be able to safeguard your client's interest. You actually don't be able to enable him to get the remedy. Yeah. This is important. So these two things are important. And the third most important thing is that you should have a positive approach. One should have a positive approach that, see, it's a profession. It's a very hardcore reality that in the profession of doctor, and that you are going to win the case. No, it's not possible. So why it is not possible? Because you can simply present the case, and then the judge has to decide what's going to be happen in this case. But you should have a positive approach, and you should have this belief system that yes, I am going to win the case. Yes. So in this way, this kind of motivation you should have in your personality, a zeal you should have a bear in your personality, so that you can attune with the client and make him assured him that the most important point is assured him with the honesty that whether he is going to win or lose the case. And if he's going to win the case, then just make him assured that yes, definitely he is going to win the case. Yeah. There is a probability, high chances of winning the case. So I believe these are the things one should have. Yeah, because it is important for us to make our clients believe that we are going to win the case. Otherwise, they'll also feel negatively regarding the case. Yeah. So, so according to you, what are the other subjects that one must focus on other than contract for being for getting into the commercial law? If he's a law student. Yeah. Yeah. So see, what I personally believe that once you've been through the contract, then you can easily understand partnership.
Yeah.
You can easily understand Sale of Goods Act. Why? I can give you an example. When we were the child, so we have majority of students must have read this line that man is a social animal. This line we all have gone through this line in our moral science book in way back when we were in 4th or 5th standard.
Yeah.
The constitution makers have understand this our feeling that man is a social animal, and the constitution makers have put this line in a different way, in a different sense, via Article 19(1)(g), right to association. And this article and this right to association has been manifested through various laws and core level and a very crux pinpoint level पे अगर हम ये right to association की बात करें, so that is partnership. Partnership Act. So these things are actually interconnected with each other. So if a person will have an understanding of contract, so he'll be able to understand the various things. For example, if a person has got the understanding of contract, so he'll get the understanding of one single. Once his word is clear to you that what do you mean by intention? What do you mean by intention? Intention means nothing. It is an immediate desire. So once you get the clarity of this word intention, you get to know that, okay, fine. If I wanted to enter into partnership, one should have an intention to enter into partnership. If one wants to sell his goods within Sale of Goods Act, so he get to know that, yes, I must have an intention to sell my goods. Because if I'm not having an intention, I won't be able to enter into a contract, and this contract will. If you have got this clarity of intention, you got to know that intention is negative sense in IPC, mens rea. If you have got this word clarity of intention in the contract, you got to know this thing once you've been through TPA, Transfer of Property Act. So within the Transfer of Property Act, majority of students get confused that, sir, this question used to ask that whether this property is movable or immovable. So the answer to this question is that what is the intention of treating that property? If you considering that property is that will be immovable. So this word is correlated within the contract with consensus addendum as well. I'm going to take another word, that is consensus addendum, the consent section. So in this way, if means I'm just giving an example that if you get a clarity of these certain words, you can create your own tunnels and enter into these subjects. So once you got this clarity of a contract, you can easily understand Negotiable Instruments Act. The Negotiable Instruments Act is nothing but you are making other person a promissory note. You are making a promise to the other person that you are going to make the payment. Okay. If you get the clarity in the contract, so you get the clarity in the SRA, Specific Relief Act. How? Because contract may, if there's a breach of contract, and there is one maxim, UB just AB remedium. Wherever there's a right, there's a remedy. In short, wherever there is an injury, there is a bandage. That is UB just AB remedy. So one of the remedy is specific relief. So once you go through this subject, you can very easily enter into such kind of subjects, very easily. So if you go through contract, then you can have a command. You can easily have a command over partnership, Sale of Goods Act, TPA. Okay, and a lot many acts. Just now I am unable to recall them. But there are majority of laws, torts as well. In torts as well, you can also have that clarity. If you can understand the nature of liability of a minor, so you can understand that nature of liability of a minor in tort and in IPC as well. This is another example.
Yeah, it was such a great explanation from your side that how contract law is important for law students like us. So everybody who is watching us would be very, interested in understanding and reading more about the contract law, definitely. So has there been any event or case where you faced some kind of crisis, and how did you overcome it?
Crisis, if you ask me that what are the crisis, when I have been an intern, at the time of interning in one office, I faced a lot of crisis. because see what are the guidance if I can provide it to you. It's all because of those failures. There is one important line has been shown in one of the ad of the TV commercials. कि दाग लगते हैं तो दाग अच्छे हैं. Ariel,
We learn
Ariel
from
said,
our mistakes.
yes, exactly. We learn from our mistakes. So I got the opportunity to draft the contract. But while I was drafting it, I actually do not have the command over the subject. So I actually face a lot of difficulty to draft it. See, one thing more one needs to understand, that is the spirit of the subject.
Yeah.
The spirit, the essence of the material which you have to draft. So until and unless you got to know this thing, ki this is what the contract is, this is what the agreement, this is what they want. These are the restraints, like restraint of trade, restraint of legal proceedings, that a person is not allowed to do this thing or that thing. Until unless there have been a clarity, so the contract becomes void. And if the consent is not free, then that will become voidable. If mistake has also been there, contract becomes voidable and a void as well. So there are a lot of things. So until and unless you've been through all these things, you will definitely face a lot of difficulties, which I have faced at that point of time as well. So that thing, that mistakes or that events has generated appetite within me, and I have to study more. And I've studied a lot, as much as I can. Still, I'm studying. I don't say that I know much about it. So it's a learning experience on a daily basis. So this is what I have faced, the things. Yeah. And I face a lot of difficulties, and then I've overcome it. And there are other ways as well to overcome such kind of difficulties, because everybody is facing it. See, theory you can learn, but in practice can only be learned by practicing only. There's no school, no college, no institution is available which can teach you how to practice. Yeah. Practice is something which you have to learn by practice only, by profession only. Profession is the only teacher. So you have to practice it. You learn at the board when the judges might reprimands you, when your seniors reprimands you. So reprimanding is really very important. I would definitely would like to suggest the students, because majority of law students and law interns, they might have got hurt that how come is it possible that a senior can chide upon us, reprimands us. Sir, reprimanding is really very important. Now, why? See, once you are dealing with judicial review and you are expecting a judiciary to correct those legislations, sir, you also have to bear those corrections. Yeah. If you are dealing in judicial review, if you are dealing in check and balance environment, then you have to be checked and balanced yourself as well. So these are the experiences. So by your seniors, by appearing on the board, by the client, they all will teach you how to make the draft in a proper way by committing mistakes. Yes. So this is a learning experience. Yeah, so you basically suggest that internships are the most important part of a legal career for a particular student. So if I may ask, how many internships have you completed in your law school? I have not completed much. I haven't interned much, but yes, see, we have with the time. I was done with 3 years law. So in 3 years law, I got the 6 times chances. So out of those 6 times, I did intern 5 times. Great. 5 times I got a chance to intern, but not in majority of offices and a very limited offices. But yes, I've interned in those offices, as if I've been interned in ASG's office, Mrs. Pinky Anand's ma'am's office. So I've been interned over there 4 to 5 times. Yeah. And in MP as well, in double AG's, as if I am a part of double AG's office. So I've interned in that office as well. So, and in one commercial firm as well. Yes, in firm as well, I have been interned as well. So I really would like to suggest the students, do just go for internship. It happens in a very initial basis, in a very in the initial basis, you really don't be able to understand the things. It happens, but don't worry, have patience. Have patience. Things will come on later on. Yeah. Just go through the theory as well. Theory part, just make it stronger as much as you can, and enter into practice. Another point is that you didn't get the time. Yeah. Very fairly speaking, you didn't get the time to study. I didn't get the time to study. So I have done with my studies in the metro. Very frankly speaking, in
Yeah.
between the two compartments, I used to study. Yes, and
Hmm.
I was very much acquainted to study in such kind of environment. So this is what a suggestion I can give you. He just study in this way and try to connect the things. Try to connect the things with the real-time experiences.
Yeah.
See, you have to study and then you have to visualize it. So
Hmm.
as much as you can visualize in reality, that will make you a good lawyer. So these are all
Definitely.
the things.
So, what is the best advice that you have given to a client who wanted to sign a contract?
If a client wants to sign a contract, then I must suggest him one important thing, that please go through it thoroughly as much as you can. Don't be in a hurry. Please go through it properly and mark those points where you find that these are the certain restrictions.
Yeah.
Even the slightest of the slightest restrictions. For example, if in a contract it has been suggested to you are signing a partnership contract, and a person is restraining you that you're not supposed to do this business or that business, please beware, then enter into it. Kindly have words with your lawyer, thereupon enter into it. So if any kind of restriction is there, please beware, don't sign it. If any kind of clarity of clause is not there, you have a doubt, and don't sign it unless you have that clarity of that thing. Now, why clarity is important? This you can learn through the theory, because section 13 talks about consensus addendum.
Yeah.
So until unless you have got this consensus addendum, that is meeting of mind. Okay, so until unless you have the meeting of mind, you are not supposed to sign a contract. You should not sign a contract. So, and the third most important point is that never sign a contract in some kind of pressure or kind of undue influence. Okay. And the fourth thing, if you get an opportunity to inquire, please inquire as much as you can. For example, if you are buying a shop or if you're buying a property, sir, do inquire as much as you can. Please visit the registrar's office. Please inquire from the other persons. Now, why I'm saying so? Because there is one important point, one important line or one important quotation. There are 9 out of 10 points in law. There are 9 out of 10 points in law. What's the meaning of that? That if a person is holding a position, it has been presumed by the law that he is the owner. He may be an owner because he is having 9 points out of 10 because he is having a position that he might be an owner. But it's not certainty. And until and unless a person is owner, you won't be able to buy a property from him. But if you enter into certain kind of agreement, your money will be blocked. So inquire as much as you can. Do visit the revenue offices, Tehsildar's office, find out the khasra, okay, and just verify it from the other persons. Thereupon just enter into certain kind of these things, agreements. And if you are entering into relationship of a landlord and tenant, then please, it's my humble request, please make him sign a rent agreement.
So basically, due to coronavirus pandemic situation in the country, everything has went online. So what are the changes do you think has occurred in contract drafting or other important aspects related to the commercial law?
See, in this, because of this COVID-19, what we have faced is one certain positive changes as well, and some negative changes as well. What are the negative changes? Like business got hampered.
Yeah.
So once the business got hampered, clientage has been reduced.
Yeah.
Because if the person is not getting a chance to construct the buildings, to have his more landlord and tenants, means if you're not getting an opportunity to get more tenants, okay, and you do not get the chance to get into some more startups. So obviously it has hampered initially. But now, as a very important saying is there, that necessity is a mother of invention. So now the business of a different level has been started online, like online coaching institutes have been established. So every such kind of people, they need contracts. So our clientage is getting, what would I say? They evolved. The evolution, we have observed the evolution, great level of evolution in the business as well, clientage as well. So this is what we have experienced. And the positive changes which we have observed, see, because of this COVID-19, we got greater associations which we didn't have before.
Yeah.
पहले वो associations नहीं थी जो अब मिल पा रही है, वो smart work, वो talented लोग जो पहले थे शायद उनसे interaction तब नहीं था, which is being possible after this post COVID.
Yeah.
Okay, so in this new normal situation, we are experiencing and we get a chance to interact with as many people as we can, or I must say, we get a chance to exchange the information with very talented people. So in this way, we are enhancing our knowledge. So this is the benefit and losses as well.
Yeah, definitely both the sides, because like law students like us, we can't go for physical internships, and that is hampering our law careers a lot. Because
and that is really very important, because until and unless a physical internship, physical interaction has been there, you couldn't be able to absorb or imbibe the things as you can. I can give you a very good example. See, you can't learn the things by typing.
Yes.
In a much speedier way, rather than you can learn the things by writing. Why? Because while writing, your nerves being pressed by the pencil or the pen, and that hits in your brain. So that puts a more impact. So this is what one problem has been occurred, but we have to remain positive. And it's my humble suggestion to you, just remain positive, nothing to be worried about it. Just try to attune with the change environment. See, change is a law of nature and we have to adopt it. And necessity is a mother of invention. So we have to acquire different ways of learning.
Yes.
Okay.
Okay. So how has your overall experience of being a commercial lawyer been?
It's a nice experience, actually. It's really a nice experience of dealing with variety of people and dealing with multiplicities of these contracts. So I truly, it's been good experience for me. And I would suggest the people that if they are looking forward in commercial law, they should enter into it. आपको बहुत ही बारीकी से जानने का मौका मिलता है. You actually get the chance to interact with people. You get to know that what are their requirements. Okay. And foremost thing is, the most important thing is you got to know that there is this kind of relationship as well, which is called a fiduciary relationship, which is not been arising out of the blood or adoption. Okay. So in this way, it is really very important. And these are all the things which one should understand. But I have been through these things. So various contracts, I've been through it. So obviously that enriches my knowledge on a daily basis. And I'm trying my level best to get some more clientage, to enter into some or different kind of contracts, so that I can also enrich some more information. So in this way, I really believe it's really been a nice experience. It's all because of one more thing as well, because of the connectivity. So I try to connect the things as much as I can. And once you have got the connectivity, so you can present the matter in a better way before the court of law. That is really very important. How you can connect the commercial law with jurisprudence. That is really very important. As if I can give you an example, how you can connect contract with Hofeldian table. There's one table of rights, duties, liabilities, power. So how you can connect the contract with that? How you can connect the contract? It's a commercial law and it's a civil law. So how you can flip the coin from civil to criminal law? How you can say that no, this is the area in which the civil law is not applicable, rather criminal law is applicable. So in this way, it is really very important. And how you can enter from contract to constitution, or rather constitution to contract, how can you just establish a connectivity with both? So in this way, not always, rather than filing a suit, you can also file WPs as well. So how you can switch and enter into the means you can file the WPs via in contractual matters. So these are the ways in which I really believe that, yes, of course, I got a great chance till now, and I really wanted to have more chances as well. Experience in this field, obviously.
Yeah, definitely. We all have to keep evolving ourselves to get more and more knowledge and everything. Definitely. So lastly, would you like to give any advice or message to the law students who are aspiring to become a commercial lawyer?
Yes, of course. As the very first query of yours, that what is the important thing and why this law is so important. So I would like to suggest the students that don't rush before the subjects, rather rush before the words. As I have discussed with you, intention, recognition, consensus addendum, okay, and person. Who is this person? Legal person, natural person. One thing. Secondly, try to break the words as much as you can. Break the words. For example, enforceability. If you get to know this is enforceability, and let's just break the word. One is enforcement and ability to get enforced.
Yeah.
So try to find out the meaning of those words and try to see that whether this word has applicability in other laws as well. Because if sale of goods have arisen from contract, partnership has arisen from contract, and if you add one word, please pay attention. If you add one word, that is conveyance. Contract plus conveyance, it becomes a sale. It becomes an exchange. And it becomes a core of transfer of property. It becomes a mortgage. It becomes a lease. So if you can correlate in this way, and you should try to correlate the things in this way only. So just don't rush before the subjects, rather rush before the these important words. That definition clause. One should always mug up, not just mug up, but go through the definition clause as much as you can. And try to clear with each and every word, whatever word you stuck up. So this is what I can suggest the students.
Yeah, definitely. So many law students like us would have gained a lot more knowledge regarding the commercial law. Thank you so much for sparing your time with us today. It was a wonderful interaction with you, sir. Thank you.